Good morning, everyone. This is Bob Heary at Barclay Damon. I want to welcome everyone to our continuing series of labor and employment webinars. Our topic for today is 10 things you need to know about the new anti-sexual harassment law in New York State. I am going to be presenting along with my partner, Rosemary Enright. And we also received quite a number of questions from the registration, and Larry Oppenheimer, who is our practice group leader of our labor and employment practice group, is with us as well, and Larry will moderate a few of those questions as we get towards the end, assuming we have time for it. I know questions may come in during the presentation. We'll try to get to those if we can as well. If not, we'll follow up afterwards. Just before we get into the presentation, I wanted to spend just a minute of your time letting you know that we had some exciting news here yesterday at the firm. We announced that we had added 20 new lawyers, including a new office in New Haven, Connecticut, and it substantially enhanced our labor and employment practice in the Northeast here. We've added a couple of litigators in our New York City office, Robert Gross and Michael Case, who will be available to help us with employment-related matters down there. Dan Blake is up in our Boston office. He's joined us, a very substantial labor and employment practitioner who also handles employment matters. In New Haven, Connecticut, we've added Penny Mason, Michael Caldwell, and Liz Acey. Liz is a preeminent employment litigator and a very excellent labor and employment practitioner. So we're very excited about our new additions. And with that, we'll turn to the presentation. So in the fall, or in the spring of 2018, as many of you know, we'll do a quick just reset. In the spring of 2018, in the light of the hashtag #MeToo movement, the Harvey Weinstein, Bill Cosby scandals that were going on, the New York State legislature and the governor approved legislation which provided for a new anti-sexual harassment law in New York State, which was very stringent, and it was codified in Section 201G of the New York State labor law and required that the Department of Labor and the New York State Division of Human Rights work together in order to develop forms of a model sexual harassment policy, a complaint form, which was going to be new as part of the anti-harassment prohibitions, as well as a model sexual harassment training program that employers could use as part of their compliance with this new law. In October of 2018, I apologize, final guidance was released by the New York State Division of Human Rights and the Department of Labor. And under that final guidance, employers were required to implement the state's new model policy or policy language that met or exceeded the model policy by October 9th of 2018, so last fall. We worked with many of our clients, and I'm sure many of you on the phone, to work through implementation of a new harassment policy that was compliant with the requirements, as well as a complaint form and training programs. What we also know is employers had to conduct required training by October 9th of 2019, and then a follow-on requirement to do refresher training every year. What we have seen, and hopefully most of you who are on the line don't fall into this bucket, but we have seen a recent spate of clients calling about training to try and get it in before the one-year deadline that was imposed of October 9, 2019. So I think all of us in the room here have training scheduled with clients in the next several weeks in order to comply with that initial training component. And then we were also required under the new statute that was in effect in 2018 to provide new employee training. When the original guidance came out, the state said that such training should be provided within 30 days. When the final guidance came out, it was as soon as possible or practicable. And what we have advised many of our clients, and what hopefully you're implementing as best practice, is you're doing that as part of the onboarding process or as soon thereafter as you can get it completed. Certainly, if you do it as part of your onboarding, you avoid the possibility of something falling through the cracks, and that's going to become even more important, I think, under the new law. And Rosemary is going to talk to us a little bit about the next phase of what happened in sexual harassment law in New York.
Yep, thanks, Bob, and good morning, everybody. So you see the skyline in New York City here, and so our clients in the upstate area are thinking, why do we care about New York City? Well, you're going to find out as we continue, but what I like to say is, where New York City goes, the rest of us are sure to follow. So Larry does a lot of work in New York City, and it's funny, he'll come back and say, my clients are doing this, this, and this, and then we turn around and we start talking to our clients here in Buffalo and Rochester and Syracuse and say, we know it's coming, why don't we start getting ready? So let's talk about what happened in New York City over the past year, okay? So in May of 2018, New York enacted the Stop Sexual Harassment in New York City Act. What is it? As you can see, it was a comprehensive legislative package aimed at addressing and preventing sexual harassment in the workplace. Basically, this was, New York put this out in addition to the requirements that New York State had put in place. And what it essentially does is it expands the New York City human rights law in cases of gender-based harassment. Now, for those of you who are not in New York City, so you know, New York City actually has its own human rights law. A lot of us on this phone deal with the New York State human rights law. In New York City, they also have to contend with the New York City human rights law, and it is very, very stringent. So with this Stop Sexual Harassment in New York City Act, they expanded that New York City human rights law. Okay, so what did it include? Well, what it changed was, it said that gender-based discrimination applies to all employers in New York City, regardless of the number of employees, right? So I think probably everybody on the phone will recall from last year with the new anti-sexual harassment laws that came out. For sexual harassment in particular, right, the human rights law in the state applied to employers with 4 or more employees. For sexual harassment last year, that was lowered to 1, but the number for everything else, all the other protected characteristics, stayed at 4, right? So that's what this is talking about. In New York City, they modified their human rights law to mimic that. Okay, so regardless of the number of employees. So if you have 1 employee, the sexual harassment prevention applies to you. In addition, sexual harassment is defined as a form of discrimination. We'll talk about that more in a couple of slides, but suffice to say, again, this is the New York City Human Rights Law was amended to include specifically sexual harassment as a form of discrimination. Now, I think probably most of you on the phone know that the time under the human rights law, New York State, to file a complaint was 1 year from the alleged misconduct or the harassment or the discrimination. Okay, in New York City, it was the same until the New York City the Stop Sexual Harassment in the Workplace Act. That expanded it from 1 year to 3 years. And again, you may be sitting there thinking, again, I'm sitting in Rochester, Syracuse, why do I care? You're going to care because, as we've said, New York City, where they go, the rest of the state follows. So you're going to learn about that in a minute or two, right? So these are the first 3 things that happened in New York City. What else? Effective this year, April 2019, employers in New York City with 15 or more employees had to conduct sexual harassment training. So Bob talked a little bit about the training in New York State, all right? And in New York City, They had to train their employees and independent contractors unless that employee or independent contractor was trained by another New York State employer with compliant training within the past year. This requirement for training has got to be completed by April of 2020, and in terms of the content, it just matches the state requirements. So again, Bob spoke a little bit about this already. We worked with a lot of our clients to help put together training materials. We have training materials, all of which are compliant with the state. New York City follows those requirements. And then finally, the new hires have got to be trained within 90 days. So in New York City, they did actually put a time frame on it. As Bob said, initially New York State said 30 days. When the final regulations or legislation came out, they said what reasonable. New York City has said 90 days. Okay? And then our last two, and again, this is New York City. We need to keep a record of all the trainings, including a signed acknowledgement by your employee. And you've got to keep that for 3 years. And as we have on the slide here, that can be kept electronically. Now, we had a couple of questions that had come in ahead of time saying, so what is the acknowledgement? What should we be keeping? Right? And so Bob and I and our team here have talked about this, and what we've been advising our clients for the past year is you can have a sign-in sheet, right? So it's got the, at the top, the training and the date of the training, and, your employee signs in and they sign out, and then you can keep that. If you decide that you want to do individual acknowledgement of receipts, similar like you do an employee handbook, so when you give someone the policy, a copy of your policy, which you're required to do, and a copy of the complaint form, you get a signed acknowledgement of receipt of that. To do similarly on that receipt, you could say, I received the training. And again, you would keep that information for 3 years. Okay, so that's what we advise in terms of the acknowledgement. And then finally, the New York City has put out posters, and in fact, the state has also, which talk about what sexual harassment is and employee rights. And those need to, in New York City, be posted, as you can see here on the slide. And right now, they're saying in English and Spanish. As new versions come out of different languages, employers will be required to post those if they have individuals in which that is their first language. So, for example, Chinese or French or Italian or something like that. Okay? So this is all, again, gang, New York City and the Stop Sexual Harassment Act. Okay? So that's just kind of a refresher. All right? So that's everything that happened before what happened on August 12th. So this is our little transition slide, and we love this slide because you can see this is from the New York City Commission on Human Rights. That is the agency that enforces the New York City human rights law. And, how many times have you heard somebody say, I was just kidding. It was just a joke. All right, and that's why they did this. So you see they cross it out and they say, it's not just a joke, it's sexual harassment. They have a second poster that actually says, it's just a hug, and that's crossed out, and sexual harassment. Now, I say a hug is, that's right on the edge. I would advise against hugging in the workplace, although we've had people call and say, she's just huggy, or he's just huggy. He means nothing by it. But, it's still a problem. So it's sexual harassment. All right, so let's talk about what's happened. So on August 12th of this year, I think probably that's why we've got so many people on this webinar with us. It was all over the papers. Governor Cuomo signed legislation. This was the headline, enacting sweeping new workplace harassment protections. Now, this was, in fact, a lot of us knew this was coming because the state legislature, at the end of its session, had put out what it said, what it was proposing, its proposed legislation. All right, so we had an idea it was coming, and they expected him to sign it, which in fact he did. And so what is it? It's a package of anti-discrimination and harassment measures that are building on what the state did last year. relative to preventing sexual harassment in the workplace. Right? But what's important, and we'll make these points throughout, is, we titled this, What You Need to Know About the Sexual Harassment Prevention Laws, but a lot of this now applies to all protected characteristics or classes, right? And that's important for everybody on this webinar to understand, all right? So it was significant when I said this was a package of anti-harassment and discrimination measures. Notice I didn't say, targeted at gender-based or sexual harassment. It's all about expanding the human rights law in New York State to protect against discrimination and harassment. So, as I said, we talked about New York City. So, you look at the title of this slide. The New York State Human Rights Law equals the New York City Human Rights Law. So New York State has now is more aligned with what was done in New York City. Okay, so that's really what's happening now. So at its core, these new measures that were signed into law by the governor on August 12th, what they do is they provide broader protection to employees of all protected categories. Okay, so you see that. It's all protected categories who have been the victims of harassment in the workplace. Okay, so that's important for us all to know. Now, again, I think probably everybody on this phone has very strict anti-harassment and discrimination policies. And we're all about having a workplace that is free of harassment, and we're all about providing a safe workplace. Okay, but, I mean, this law, that's what it's targeted at. All right. So, and the next, I'm sorry, I got myself tripped up there. What else does this? What else is the basis, or what is this new legislation targeted at? Well, it lowers the burdens for the employees to plead and prove harassment. And I think this is what's got everybody concerned. So we had a lot of questions about, what does it mean, no severe or pervasive? We'll talk about that in a minute. And then it eliminates some defenses that employers have got under federal law. So really, if you were to summarize this new legislation, that's what it does. Those three things right there. And at the end of the day, what it does is it enables individuals to assert and prove more easily a discrimination complaint. All right, so let's now get into what our 10 things are. All right. All righty. First of all, this is what I already hinted at. All right, there is now a lower standard for proving discriminatory harassment, and it's actually codified into the human rights law. All right, so I think everybody on this phone knows what the current standard, or I shouldn't say the current, what the standard was. So the standard was severe or pervasive. So when, a lot of our policies would reference severe or pervasive, when we responded to charges with the Division of Human Rights or with the EEOC under Title VII, we would often say the conduct was not severe or pervasive. Years ago it was severe and then it was severe and or, and now that standard is gone. All right, so what is the new standard? So the new standard is, or the way you could think of it is, an employee or an independent contractor, Bob will talk about that, or some other vendor, someone who has a contract with us, may prevail on a discrimination or harassment complaint if they can prove that they were subject to inferior terms, conditions, or privileges of employment. And so that's the standard, inferior terms, conditions, or privileges of employment. All right, so, and you're all sitting there thinking, what on earth does that mean? Well, and I think several of you, or a lot of you, have been on these webinars with Bob and I, and, he and I will chat about these things. It's, like coffee talk on Saturday Night Live, but, when you talk about, like, inferior terms or conditions, in my mind, tell me what you think, Bob, if I'm going to be putting in a position statement for, fighting a discrimination complaint, I'm going to look at, well, I'm going to say, you know what, I've got all these individuals that we pay them this, this, and this, and they've got these benefits, and they received this training, and they had this promotion, and so the terms, the conditions, and the privileges were the same across the board. That's how I'd be speaking to it.
And I think that's right in terms of discrimination generally, but I think when you start to talk about harassment specifically, when you take out severe and pervasive, I think honestly, the standard will be developed over time as the courts and the Division of Human Rights look at these cases. This is going to evolve through case law in terms of, you know, what used to be considered a petty slight may no longer be considered to be petty. What was severe or pervasive, as you point out, that standard's gone by the wayside, but it's presumably conduct which is something more than a smile or a wave.
Right. Or a wink.
I don't know about a wink.
A wink, you're right. That's right. I suppose a wink could be problematic down the line.
And so I think you've articulated what the standard is, and certainly with respect to discrimination, you know, we can put a box around that, but harassment is going to be a little softer and squishier, I think, and I don't think we will know the full range of how it will be analyzed by the courts and the Division of Human Rights until we see what happens with litigated cases. One thing that I wanted to note on the slide here, we have in all of these 10 items.
I was just going to say that.
60 days. Okay,
yes,
go ahead.
Thanks, Bob. I was just going to say that. So you'll see after that it says, in parentheses, it says 60 days. What that's indicating is that 60 days after August 12th is when this particular provision, requirement, whatever you want to say, whatever you want to refer to it as, goes into effect. And so for those of you 60 days that don't want to sit and count on the calendar, that's October 11th. So anything that has 60 days after it goes into effect October 11th of 2019. So that means any claims of harassment that are filed with the New York State Division of Human Rights, you know, on or after that day, this particular standard will apply. Okay? So the other thing, the other point I'd like to make around this, the lower standard, the inferior terms, conditions, and privileges of employment is the employee need not identify another employee to prove harassment. So in the past we had, you know, we would talk about the comparator and that. Don't have any of that anymore, okay? So I can say, I was treated this way. I received these inferior terms, conditions, and privileges. Don't have to point to anybody else. Okay, so that's the first and probably the most significant. I think that's what has stressed people the most, and so that's why we started off with that. Okay, number 2 on our list, right? So this one, the discriminatory harassment is codified into the human rights law. Again, 60 days, this goes into effect. Where did you see this? We just talked about it in the New York City Human Rights Law section. So I said that they had changed the human rights law in New York City. They've now done it in the state. Now, you may be looking at this saying, so I don't get this, Rosemary and Bob. What does this mean? Right? Well, so harassment, right? So 30 years ago, the Supreme Court interpreted the federal law to include sexual harassment or harassment in the anti-discrimination laws. Okay, so it was in effect court-defined law, right? But it wasn't codified in the actual laws themselves. And so the change now is it is actually in the law. So it now says that it is illegal to harass an individual on the basis of their membership in a protected class. All right, so notice I'm not saying it's something around sex or gender or something. It's in any protected class. Right, and actually going back to number 1, let me just make the point where we say the lower standard for proving discriminatory harassment, That is not just for sexual harassment. That is for all protected classes, all protected characteristics. So if someone claims discrimination or harassment on the basis of race or national origin, if the standard is inferior terms, conditions, and privileges of employment. Okay, this is at New York State. Realize at the federal level, severe pervasive still exists. And I think Bob may touch on that in a bit. Okay. Number 3 on our list, the Faragher-Ehlers defense eliminated. You're like, what on earth is that, Rosemary and Bob? I've never heard that. All right. So again, 60 days, October 11th, 2019. What is this? Right. So again, if some of you, if you've had to file or respond to complaints of harassment or discrimination, we will often say, okay, so we have a process. We have a harassment or an anti-harassment policy. We have a complaint process. Okay, so we have preventative and corrective measures in place, and the alleged victim, the complainant, did not avail themselves of those measures. In other words, they never filed an internal complaint. All right, so that is the defense that an employer would use. It's based on a pair of Supreme Court cases. All right, so if an employer said, we have these preventative and corrective measures in place, and this particular individual never avails themselves of it, that was one of the defenses that an employer could use defending against these types of complaints. That is now gone. All right, so what happens? Okay, so all right, so Rosemary and Bob, we don't have severe pervasive. Now we can't say, listen, we did all of this. We had all of these measures in place. The employee they never told us. I mean, what are we left with? How do we defend against these types of claims? Well, all is not lost. You as the employer can prevail or prove that or defend against these types of harassment claims by showing that the standard is that a reasonable, or rather, I love the language, a reasonable victim would find this to be a trivial or a petty inconvenience. All right, so that would be the defense at this point. Now, we had quite a few questions asking us, all right, well, so what does that mean? All right, so what is a petty, slight or a trivial inconvenience? And unfortunately, the lawmakers gave us no guidance. Okay, so they gave us no guidance whatsoever, and this was the point that Bob already spoke to. He said he thinks, and I agree with him, that this is just going to play out. It's going to play out in the courts and in the division and so forth as they try to figure out what this is. So the case law right now is scarce on what a petty slight or trivial inconvenience is. But at the end of the day, if somebody complains of harassment, we all know what you're going to do, which is you're going to conduct an immediate and a thorough investigation, and you're going to take whatever action is needed to make sure that if someone is uncomfortable in the workplace, that we correct that. Okay, so, and one other thing, Bob, just 1 second. I had just wanted to tell you, so, and I've got this written down because I wanted to read it to you and get the wording right. The question is always, so why would they get rid of this particular defense? And this was the language. They're rejecting that because none of this, if we had that defense in that, all right, it doesn't offer an incentive for creating a zero-tolerance workplace policy against demeaning behavior toward members of a protected class. So that's why they're saying that it isn't enough, because in other words, they don't want an employer hiding behind, well, listen, we did what we could, and oh well. Okay, so the whole point is there should be no demeaning behavior in the workplace. It should be zero tolerance. In theory, that's what this law is trying to enforce. I'm sorry, Bob. I just wanted to finish that thought. Go ahead.
Well, since we freaked out everybody who's on the phone, I just wanted to take a step back for a minute and say a few things, which is, so the Faragher-Ehlers defense, now recall, was only available if it was coworker sexual harassment, right? It wasn't available when you had a supervisor and a subordinate. And these niceties about the legal standard and everything else, you know, that'll all play out in the course of litigated cases that, you know, hopefully none of our clients have to defend against or on this call, because they're going to do what they need to in order to create that environment that you're talking about. But at the end of the day, you know, the takeaway, I think, from some of this is just a reinforcement of the need to be proactive when it comes to these sorts of issues that come to your attention. You may have a more difficult time at the Division of Human Rights. You may have a more difficult time defending a case in the courts, but risk mitigation, risk management starts with how you treat the employee when they come forward, or when you learn of a situation where somebody is acting inappropriately. And a lot of times, as I think most, if not all, the people on the phone know, and as we know, it's that effective interceding and trying to create a workplace that is non-discriminatory. You're always going to have a few rogue agents, and we have to be mindful of that. But at the same time, I think while all this landscape is shifting and it will result in more litigation and more claims, you know, the way we can manage day-to-day, boots on the ground, the risk associated with all this is by having effective processes in place that provide the avenue for the complaint, result in us taking it seriously, result in us taking appropriate disciplinary action, and notwithstanding, you know, all of the niceties and the legalities, we're gonna try to manage that workforce in the same way that we have previously, you know, to affect a policy and a program and environment that is non-discriminatory for all of our employees. So I just want to interject because I think people are, you know, their stomachs are tightening if they're listening to all these things that aren't available.
Right, exactly.
And while not the subject of this particular webinar, but what we've covered in previous webinars is how to do the training that's required under the state and city human rights acts. And that training requires employers to meaningfully convey to their supervisors and managers the responsibilities that the supervisors and managers have to keep the workplace free from harassment. So it's no more digging your head in the sand and ignoring what's going on in the cube farm. It is actively managing the workforce consistent with the state's goals of a workplace that is free from any forms of harassment.
Right, exactly. Well, and, you know, one of our slides, I think some of you have participated in, you know, our webinars in the past. We've got a slide that I can't remember the colors, I think it's red and yellow, and it says, you know, open door, let them complain. You should always be listening. As Larry said, no head in the sand anymore. All right, and then number 4 on the list, this is just like we talked about with New York City, the elimination of the employer coverage threshold. Now, and again, New York State human rights law for employees, right? Last year they changed it to 1 for sexual harassment. This employer coverage threshold now applies to all protected classes. Okay, because again, remember this package of anti-discrimination and anti-harassment measures that the governor signed into law on August 12th is expanding the human rights law to protect all, right? So not just specific to sexual harassment. So now you have 1 employee, you've now got you've got to deal with disability and race and so forth. Okay, and I'm going to turn it over to Bob now.
Thanks, Rosemary. And continuing with our list, as Rosemary alluded to earlier on, the new law now includes coverage protections for non-employees. So any person who's providing services pursuant to a contract in the workplace can recover for any type of discrimination. So what does that mean? It means we need to be mindful of what's happening with temporary employees who we have coming into our workplace. We certainly always have been, but I think even more so now, we need to be aware of these protections with respect to temp employees, independent contractors who we may have that are not necessarily employees. You know, we pay them on a 1099, but they provide some regular services or are otherwise in our workplace. Those folks are now covered and can bring a claim if there is any form of discrimination with respect to the relationship that they have with the employer. Did you have something? Oh, I'm sorry.
No, that's okay.
So that's number 5. And number 6, can seek to recover uncapped punitive damages and attorney's fees against private employers. So what we used to see was a lot of the plaintiffs' bar would bring claims that would consist of both a federal claim, let's say under Title VII for discrimination or sexual harassment by way of example, and you could under Title VII get your back pay and you could recover compensatory and punitive damages, but those were subject to a cap based upon the Civil Rights Act of 1991, and that cap was a sliding scale depending upon the size of the employer. But you could also get your attorney's fees under the federal statute under Title VII. In New York, you could get compensatory damages, but you couldn't get punitive damages. And the compensatories were uncapped under the New York Human Rights Law, but you couldn't recover attorney's fees. And so, you know, the plaintiffs' bar would combine their federal court and their state court action, and they would be able to get you know, compensatories without a cap, attorney's fees, all these different forms of relief. Well, now we have added really this concept of uncapped punitive damages under the New York Human Rights Law, because punitive damages, you know, previously were not available under the Human Rights Law, and they were subject to a cap under the federal statute. So now there is, you know, free reign, I guess, for a greater level of exposure. Now, punitive damages will only apply where you can demonstrate, the plaintiff can demonstrate that the employer's conduct was, you know, above a mere negligence. But you need to be aware that the exposure and the ballgame has changed a little bit as it relates to punitives. And again, you know, some employers, smaller employers, wouldn't have met the thresholds for coverage under Title VII, but because the Human Rights Law now is eliminating the coverage threshold so that one employee, you're going to have the ability to see larger awards against any employer in New York. Non-disclosure provisions in settlement or separation agreements. This is a really, you know, this is a completely new and different thing. It came out with the 2018 legislation that I talked about in the original bill that was passed and signed into law. And what it did was, in the original law, it applied only with respect to sexual harassment. The big change is the underline in number 7 here, any discrimination complaint. So now what we're looking at, when the law first came out in 2018, the way the legislature dealt with this is they amended the New York State General Obligations Law and the New York State Civil Practice Law and Rules in order to put in a mechanism for confidentiality provisions, non-disclosure provisions, to be incorporated into either a settlement agreement related to a claim or a separation agreement. And the way it works is it's kind of like the Older Worker Benefit Protection Act, but it's not exactly the same. So, like the Older Worker Benefit Protection Act, the employee needs to be provided 21 days to consider whether or not they want the agreement, whether they prefer the agreement to be confidential. And that's the language that's actually used in the statute, whether it's the employees or the complainants or the plaintiff's preference that it be subject to a non-disclosure provision. And that 21 days, though, unlike the Older Worker Benefit Protection Act, was not waivable. And so the employee has to be given 21 days to consider whether or not they prefer that the agreement not be subject to disclosure and to be confidential. And then, after that 21-day period, they have to be provided 7 days to revoke that agreement. And so the New York State guidance on this, actually, there's an FAQ that asks, so are there two documents? And the answer from the New York State Division of Human Rights is yes, there are two documents. And the first is the one that you give to the employee to let them know that that you might be interested in having an agreement where it includes non-disclosure and confidentiality provisions, and whether the employee would prefer that that be the nature of the agreement that they enter into. And then only after the 21-day period has passed, again, not subject to waiver, then sign the agreement with the non-disclosure provision in it, and then 7 days after that to revoke. So it's a very cumbersome process. It's somewhat unrealistic, I think, in terms of the way separation agreements. It's one thing if you have to do it in connection with a settlement of a charge of discrimination or a lawsuit or that sort of thing, but it's in that separation context where it gets kind of knotty because, as I say, it can be a little cumbersome. So that's something to be mindful of because it relates to any discrimination complaint, unless it's the plaintiff's preference. And so 60 days, this becomes effective October 11th, 2019. And if you we're going to have to look at questions such as, if it's just a separation agreement that has a general release of claims where there's been no claim that's actually been made or asserted by the employee, well, then does any of this apply? Because you would say it doesn't.
I would say it doesn't. In fact, I was going to chime in because I had a note here that, if there's no underlying sort of discrimination dispute, then this doesn't apply.
Right.
Yeah.
But a lot of times, separation agreements come about in the context of a claim that may be asserted. So if you're doing a reduction in force or, you've decided it's time to let somebody go because of performance, that sort of thing, these things don't apply. But if you're in a situation where you're trying to negotiate yourself out of an uncomfortable or difficult situation, they might come into play. So just be mindful of that. Employers may not force individuals to arbitrate discrimination complaints. And this one is another interesting one. And it's more interesting probably to us as lawyers than it is to the folks who are on the phone. But I know a lot of people have considered, some have implemented mandatory arbitration agreements. And so with the 2018 legislation, there was a restriction on arbitration agreements in the context of sexual harassment complaints. This, again, expands it to all discrimination complaints. This is an amendment to the Civil Practice Law and Rules here in New York. And it has a couple of exceptions that are built in, and they were built in 2018, and they're built in again with the most recent iteration. And one is, if there's a collectively bargained agreement that provides for mandatory arbitration that might cover discrimination type of claims, then the terms of the collective bargaining agreement would supersede Most collective bargaining agreements have an arbitration mechanism. Not a lot of them actually call out discrimination complaints specifically. So, but if there is a collective bargaining agreement that does call those out and they're subject to arbitration, that will hold up. The second, another exception, and this is the one that's interesting, is that the legislation has sort of a savings clause that says, and not where inconsistent with federal law. And so nearly at the same time that the legislature came up with the 2019 legislation and passed it, while it was being passed and sent off to the governor to be considered and ultimately signed in June of 2019, this year, at the end of June, there was a case down in the Southern District of New York, which is down in the Manhattan, Westchester area, and it involved Morgan Stanley and an employee who had sued under the 2018 legislation, and the defendant, Morgan Stanley, moved to compel arbitration under an agreement that they had with the employee. And the employee said, no, I can't be required to arbitrate these claims because it's against the law. The New York CPLR has been amended, and it prohibits this. And the Southern District of New York, which is the federal court down in, again, Manhattan, they said, no. The Federal Arbitration Act trumps these amendments to the CPLR, and therefore we are going to rule that you have to go to arbitration because you've signed this agreement. So it's an interesting, confluence of circumstances where a federal district court in New York is assessing the 2018 changes and saying, no, those are overridden by the Federal Arbitration Act. And at the same time, the legislature and the governor are passing an add-on to the law that the federal court has now said is preempted under federal law. I don't know that this is going to be the last case that addresses this question, but I think having this district court decision, I don't know whether it'll be appealed ultimately, but having this district court decision would suggest that employers who choose to continue to have mandatory arbitration provisions will be able to enforce those. Larry, I don't know I know you've been following this and you had a lot of comments.
I agree completely. And interestingly, within the last several weeks, the NLRB looked at the question of mandatory arbitration agreements with class action waivers and found that, it's the Trump board, but they found that they didn't violate the National Labor Relations Act and that an employer can seek, even with represented employees, those types of agreements. So you're right, the last chapter has not been written.
And one of the things, assuming that the Southern District of New York case holds up, and I think the Southern District got it right, more and more employers faced with all of the things that we've talked about may give consideration to whether or not they want to have mandatory arbitration agreements. There's pluses and minuses to arbitration. There's pluses and minuses to mandatory arbitration agreements. But certainly it's something that employers have been looking at for years, and the law seems to be coalescing behind the idea of enforceability of these types of arrangements, and so we may see more employers looking to adopt those types of programs for their employees, all their employees, whether represented or not. We have an enhanced distribution requirement of sexual harassment prevention policies and training materials. Immediately, that means this went into effect at the time that the law was signed by the governor. And basically, what you want to do is you want to be providing your policy to your employees at onboarding, the day that they're starting. That sexual harassment policy ought to be right there with everything else that you might go over on that first day of employment, and ensure that the employee has a copy of your policy. And I'd actually have it as probably a standalone policy. Some employers have had this for a long time. Some just have it in the handbook. It's easy enough, I think, to have them sign off that they've received that particular policy. I know somebody asked about separating policies.
Yeah, there was a question and asked, do I need to separate my anti-harassment and my sexual harassment policies in my employee handbook if I have an employee handbook?
And, we, starting last year when the 2018 legislation came out, we advised our clients that they should separate those policies if you had two policies, because there is this model policy for New York State with respect to sexual harassment specifically, and a lot of employers had combined just into a non-harassment. It may go back to that given these changes that we've seen in 2019, but for now, because that New York State model policy on sexual harassment is out there and it contains a number of bells and whistles, it probably does still make sense to have a sexual harassment policy and then a non-harassment policy with respect to other protected categories. And again, both of those would be presented to the employee at the time that they're starting, so that they're aware.
But my takeaway from your presentation this morning is that notwithstanding the fact that you may have implemented a new policy to meet the legislation effective October of 2018, with these new amendments in place, which are effective in 2019, we should review our policies that we adopted last year to make sure that the standards that are now incorporated into the law are incorporated into that policy.
Exactly. So if you have language in there, which a lot of policies do, that talk about use the language of severe, pervasive, and that clearly that needs to come out. Exactly. And the other thing to this this enhanced distribution, as Bob said, should be part of the onboarding process. In New York City, you are also required to present the employee with a fact sheet. And there's a copy of the fact sheet online. You can get it. If you're not sure, just send us an email. We can direct you to it, but you've got to give them the fact sheet and your policy, and you should be talking to them or giving them an outline that talks about the training that you conduct. So remember, in New York City, you've got to do it within 90 days. In New York State, it's within a reasonable amount of time. But this whole notice is, here is our sexual harassment prevention policy. Here's our anti-discrimination. Here is our complaint form. I would advise that you be giving them that complaint form because it goes hand in hand with that policy. In New York City, you're giving them fact sheet. You're telling them, here's the training. You'll be taking it on this day, and this is what's covered in it. And you've got, of course, your signed acknowledgement of receipt that I received all of these things.
Is there a requirement, one of our participants has asked, is there a requirement to present the anti-harassment training in person, or is an email version, including the policies, videos, and an opportunity to ask questions via email, an acceptable way of conducting the training under the New York State human rights law?
Yeah, so our answer to that is it is acceptable if you're doing something. I'm going to refer to it as online training, so long as you are certain that that training is compliant with New York State. So New York State has very specific requirements as to what needs to be covered in the training. So long as it is compliant with that content, and it must be interactive. So you're sitting there thinking, well, if we send it by email or a video, how is that interactive? What they mean by interactive is, are there questions in there? Is there a quiz so that the individual has to go through and actually respond and be engaged with it? All right. In addition, at the training, they should have the name and contact information for someone within the organization to whom they can contact if they have questions after taking or completing the training. All right, and then of course you'll want an acknowledgement that they completed that training. Okay, and the only other thing I'd say, and Bob and Larry, please chime in from my opinion is for your rank and file, I'm fine with you having them do this, New York State compliant interactive video, and if you're sending out all the materials via email and so forth, fine with that. I would suggest that your managers be trained with what I would refer to as instructor-led training. So, you've got, someone like, for example, we come in, we're doing a lot of training, as we've just said, over the past couple of weeks. If you've got some organization that you work with, have them come in and work with your managers, because we're not going to get into it in this particular presentation, but there is a higher expectation for the supervisors, and there are requirements. And you want to make sure that your managers are properly trained so they're listening and they're seeing and they're paying attention and they know how to respond properly. So
I would agree with all that, including, it doesn't have to be the only thing I would say is it doesn't have to necessarily be an outsourced vendor. I mean,
no. Oh, yeah, I'm sorry.
Certainly in-house capabilities to conduct the training as well.
Yeah.
But I agree 100% that the supervisor interactive training, meaning sitting in a room with instructor-led training, is going to be the most effective training for the supervisory group.
Yeah.
Speaking of training, and the last question that we got on the training issue is the annual training requirement. Is that on a calendar year annual basis? Is it in the employee's anniversary date basis, or is it 12 months from the time that an individual employee received the training?
Yeah, so the annual training requirement is not specified as to whether it's one of those categories that you talked about, Larry, in the guidance from New York State. It simply says annual. So, employers had until October 9, 2019 to complete their annual training. And what I would say is annual, if you did your training at the end of 2018, as some employers did because of New York government contracting requirements that they were subject to and that became effective before January 1, 2019, you probably want to complete your training in 2019, your annual training, before you get to the next calendar year. If you did your training, let's say, in the first quarter of 2019 because you just wanted to get ahead of the curve, but you didn't want to, you didn't want to be right up against the deadline, but you didn't want to implement too early, then I would say, you're probably on a calendar year basis, and so you did it in 2019, do it in early 2020. If you're one of the stragglers who is just finishing up before the October 9th, 2019 deadline, then I would say your out date should be October 9th, 2020.
I agree with that. Yeah, I agree with that. Yeah.
So you should do training in 2020 at some point, and it should be before, this October 9th deadline.
Yeah. So,
and we have the 10th item. Individuals can file a complaint of sexual harassment within 3 years versus 1 year, and this relates to the complaints with the New York State Division of Human Rights.
Right.
So before you under the federal statutes, you have 300 days from the time of the alleged discrimination or harassment to file a charge with the United States Equal Employment Opportunity Commission. Under the New York State human rights law, you have a period of 1 year to file an administrative complaint. You have 3 years to file a lawsuit in New York State Supreme Court. But for those who choose to go the administrative route, you have 1 year, and that 1-year period will now be expanded to a 3-year limitations period, so that an employee can go to the Division of Human Rights 3 years, up to 3 years after the alleged discrimination or harassment, and file a charge. That's going to be burdensome, I think, on employers if for no other reason. We know from experience how the wheels of justice move over at the Division of Human Rights, and if you end up getting caught up in first the investigatory stage, but then it goes on to an administrative stage, now you're talking about quite some time before you're getting to a hearing in front of an administrative law judges. And so, people's memories fade, witnesses are no longer with the company, and that sort of thing. So it's going to just add a little bit to the burden of defending one of these claims if there are stragglers who decide to wait 2 years and 362 days to file their discrimination claim against an employer.
And that would be untimely.
And,
that would be untimely under the federal statutes, but now timely under the state.
We're over our time.
We want to be respectful.
So make sure you're compliant, make sure you have your notices, policy and complaint forms are available, your training being conducted on a regular basis. Remember, every allegation of discrimination, harassment, or retaliation must be taken seriously, must be investigated, and if you are a supervisor or manager, you need to report those immediately. We expect our employees to report them as well, and we publish that in our policies. Thank you for your attention, and we look forward to seeing you next time. Take care, everyone.